I'm Jimmy May, and on behalf of myself and Aaron Daly, we'd like to welcome you to this segment of the Good Legal Stories series, a corollary to the Good Stories movement sponsored by the Normandy Chair for Peace, an endeavor whose motto is, "We will have peace on earth when we have peace with the earth." To that end, the Good Legal Stories series spotlights landmark environmental advocacy from around the globe through the voices of those who made it happen. Today, we're delighted to have with us Marigel to tell us the good legal story of her role in Ecuador's adoption of rights of nature in Chapter 7 of its Constitution. Erin?
Thank you, Mari. It's so great to have you here. Let me just briefly introduce you. Mari Margil is the Executive Director of the Center for Democratic and Environmental Rights, CDER. She's a graduate of the Kennedy School of Government at Harvard, and she works closely with civil society, national, state, and local governments, tribal nations, and indigenous communities all over the world, in the US, Ecuador, Australia, the Philippines, Nepal, and elsewhere, all to advance the rights of nature frameworks. Of particular relevance to today's conversation, in 2008, she consulted with the Constituent Assembly in Ecuador, helping to draft the world's first rights of nature constitutional provisions. So we're here today to learn a little bit more about that experience. So Mari, will you tell us about your work with the Constituent Assembly in Ecuador?
Thank you for having me, Erin. Jimmy, it's good to join you and share this good story, which I believe it is. Ecuador in 2007 and 2008 embarked on the drafting of a new constitution for the country. And we were fortunate, the co-founder of the Center for Democratic and Environmental Rights, Thomas Lindsay, and myself were able to participate in that process. And that came about, Ecuador, as folks may know, has incredible ecosystems and species that are really unique anywhere in the world. And the protection of those has been greatly under threat, particularly from extraction by multinational foreign companies coming into the country and causing all sorts of havoc in the Amazon and other regions. So in 2007, 2008, we were invited to go to Ecuador, meet with members of the Constituent Assembly, essentially their constitutional convention that was drafting the new constitution. And this occurred with the organization Fundación Pachamama, who became familiar with our work to advance legal rights of nature within the United States and asked us to essentially bring that story to Ecuador and the Constituent Assembly, the delegates there that were tasked with drafting different provisions of the Constitution. And so we did that. And truthfully, we were unsure of what we were embarking on. It was the first time that the rights of nature had been considered, within a legal framework outside of the United States. Up until then, beginning in 2006, you have small communities in the United States that had begun to establish and codify legal rights of nature within local municipal law. Thomas Lindsay had worked with the first communities anywhere in the world to put these into binding legal frameworks at the local level. And that's the first place that had ever occurred. And so moving into a national constitutional framework was, considered by us a real big leap. And we were uncertain what that looked like, how that would happen, if it could happen. But of course, we saw it as potentially a good opportunity just to bring this dialogue within this constitutional convention process. And so we went. And we were invited to meet with the different committees within the Constituent Assembly. And so they had essentially divided up tasks for drafting different parts of the Constitution. Like a MESA, or a committee that was focused on drafting the section of the Constitution on fundamental rights. Another MESA, or committee, that was focused on development or environment. And other kinds of committees were established. We met with those that were focused on environment and development, as well as the Fundamental Rights Committee. And we essentially had a dialogue, a conversation with these delegates, which included a number of Indigenous delegates that were elected to this Constituent Assembly, as well as non-Indigenous delegates. And we discussed the kind of threats that were faced by different ecosystems and species within Ecuador, and their inability to stop these threats under existing environmental legal frameworks that existed at the national level there. And the rights of nature was a discussion about how do we essentially shift so that our environmental legal frameworks are focused on first and foremost protecting ecosystems, protecting species, as opposed to what conventional environmental law does today, which is legalize the use and exploitation of ecosystems and species. And that was a really interesting conversation about how to move in this really new area of law. And what was most interesting to us is talking about the need to protect and elevate the level of environmental protection in Ecuador. We expected that. And we had a lot of those conversations. But what we didn't expect was that we would be invited to meet with the MESA or committee focused on drafting the section on fundamental rights. When we think about fundamental rights, we think fundamental rights that human beings have within a constitutional framework, like our right to free speech, or our other rights, our right to equal protection, other things like that, those sort of core fundamental rights that human beings possess under many constitutional frameworks. But here we were invited to talk about it within not human beings having fundamental rights, which of course is included within Ecuador's constitution, but nature having a fundamental right, a right to be. And so those are the conversations that evolved and ultimately moved into a drafting process for these new provisions in Chapter 7 of Ecuador's constitution, which was then part of the larger constitution that was put to the voters of Ecuador in September 2008. And they ratified that through a national vote. And the rights of nature, what they call Pachamama, was recognized for the very first time anywhere in the world as having constitutional rights as codified, promulgated, ratified within a national constitution.
That
Well,
is
that's
a cool story.
Really is. And what would you say, in your estimation, is the importance of that provision internationally on the global scale, in other countries that are considering amending their constitutions or adopting legislation recognizing the rights of nature, and then also subnationally in the United States and elsewhere?
It's one of those, as we went through the process, number one, I mean, we had no idea if this would ever make it into even the debate, that the Constituent Assembly was having, let alone into provisions that they were considering and voting on. And as that process went forward and we saw this development, that it was moving along, that it was being incorporated into the provisions, and ultimately that it was voted on and ratified within the National Constitution in 2008. That whole process for us is really quite unexpected. And we, from there, didn't know what to expect when the Constitution ultimately was finalized and ratified that year. And what we didn't know what to expect and didn't quite prepare ourselves. What happened next, happily, was that people actually took notice. And that meant that we started getting phone calls and emails from different parts of the world. The first places that we got calls from, number one, was Nepal, which itself was moving into a constitution drafting process. And civil society organization contacted us and said, we saw what just happened. We're really interested to determine, see if we can do something similar here in Nepal, particularly as Nepal is facing severe impacts of climate change to the Himalayan mountain range, which is the fastest warming mountain range on Earth right now. And so they were going through a similar constitution drafting process. And so saw what happened in Ecuador and said, what can we do? Can we do something similar? We also, one of the first calls we got was from India, for people wanting to protect the Ganges, Mother Ganga, the most sacred river in that country, which 500 million people depend upon, and yet it's facing great severe pollution, water withdrawals, all sorts of harms occurring to this magnificent river, and wanted to see what can we do within the rights of nature framework to protect the Ganges River. And then it's kind of grown from there. And it was kind of this journey that I think still continues, that people see what Ecuador did. And even if they're at the most local level and facing something like fracking in their community and trying to stop some, that which brings great environmental harm and harm to the public health, they're seeing what happened at a national constitutional level and saying, hey, maybe we can do this here in my community, or maybe we can do this here in my country. At all levels, I think we have seen the impact of Ecuador for people to not only say, hey, can I do that, but, oh, that's possible. I had no idea that was possible. Somebody's done it. They went first, they took the big leap. And maybe we can do that here. I think what it did was kind of open up a lot of minds to say, wow, that's really fascinating, that's really innovative. That represents what a lot of people I think have been searching for, which is, as we see, unfortunately every single day, headlines about climate change accelerating, species extinction accelerating, ecosystems deteriorating, collapsing. I think people are beginning, even then, 10, 12 years ago now, that's something really fundamental needed to shift in humankind's relationship with the natural world. But what is that? And people all over the world are living under environmental frameworks which are legalizing environmental harm and saying we need to do something different. And Ecuador took a big step toward that. And we see the consequences, which are these beneficial consequences. We see courts in places like Colombia, in India, Bangladesh, recognizing that rivers and other ecosystems possess legal rights, even the most basic right of a river or other ecosystem to exist. That all got spurred by Ecuador taking a big leap forward. And we see a lot of law and policy making occurring locally within the United States, being energized and driven by what Ecuador did, but also in other places like in Brazil and Uganda and elsewhere, that we're seeing these rights of nature legal and policy frameworks moving forward. And it took this sort of big leap forward that Ecuador did, that I think has led to all sorts of opportunities and possibilities for really changing how we govern ourselves toward nature. And so I think it's hard to, I think overestimate how much the impact Ecuador had. I think we're still seeing it. But I think it's really driven a lot of people to understand that change is possible. And that's a good news story for sure. But how they did it is still being studied, it's still being watched. We still get, we're still working there to move into proper implementation and enforcement. And it's still being studied to determine how do we follow in those footsteps, big footsteps, but how do we do that? And I think that's an incredibly positive and important story.
Yeah, absolutely agreed. I guess I'm really interested in that how question. I think, I'm sure everybody watching this would agree with you that the current state of affairs and the current way that we regulate the environment and really regulate the degradation, allowing the degradation to it, is not getting us to the level of environmental protection that we need. And I'm wondering, from your perspective, why was the answer to completely shift the paradigm rather than just saying, let's just have stronger environmental laws, let's protect the environment, but we just haven't done it enough. But I think what you did was really quite radical in not just forcing sort of a new right, but really compelling a new way of thinking about rights. And I'm just wondering if you can tell us a little bit about why you felt that step was necessary, and also the conversations that you had in Ecuador presenting that to people and the kinds of reactions that you got.
Yeah, I think that's a really important question. Within Ecuador, the very large indigenous population, and the indigenous population, I think, has been very much on the receiving end of so much of the harm that's occurred, particularly from, as I mentioned, extractive industries, multinational companies coming in and drilling in the Amazon and other kind of, mining and other kinds of extraction. And in some of our conversations with Indigenous delegates to Ecuador's Constituent Assembly, we had just discussion about this, and it's deeply painful, and it deeply impacts their day-to-day lives and ability to live on their traditional lands. And some of the Indigenous delegates talked to us about how the Constitution had recognized the collective rights of Indigenous peoples, which was a very important, powerful thing for them to be able to protect where they live and how they live. But it wasn't enough, and that the rights of nature essentially expanded out and strengthened their collective rights as Indigenous peoples. And the rights of nature, not only in Ecuador, but in other places where we work with tribal nations in the United States, we work with First Nations in places like Canada, and Indigenous peoples in other parts of the world. And while recognizing legal rights of nature may seem strange to non-Indigenous peoples, we have found, at least initially, we have found that Indigenous peoples are readily understand this concept of nature possessing legal rights to be, to regenerate, to exist, to thrive. And that comes out of as we might hear in Ecuador, like a cosmovision, but essentially a way of living that recognizes that nature is a relative, that we are part of nature, we depend on nature, and that it's part of our community. And so many have said to us, in so many words, that the rights of nature essentially codifies this relationship with the natural world that they already have. It just puts it into essentially written law, and provides a means, a foundation in the legal realm to be able to enforce those rights when threats come. And so that's been a big part of the conversation, not only in Ecuador, but with other Indigenous communities as well, that we have experienced as the rights of nature legal framework has evolved, over the past decade and a half at this point. And that, I think, continues to impact non-Indigenous communities as well, who are seeing a need to, essentially make this really dramatic fundamental shift in how we govern ourselves toward nature, how we recognize ourselves as part of the natural world, moving us past, recycling more and composting or driving a hybrid car. Those are good things. But making these kinds of really big changes to even our basic governing frameworks, I think is becoming more understood, more commonplace, and the rights of nature, I think, is right there at that center of that need to make a fundamental shift in how we make that fundamental shift.
So, Mari, let me ask you just one final question, and then we'll wrap up. This has been fantastic. What do you think, or how your experience might inform what the younger generation is thinking about in terms of nature justice, going forward? What lessons are here to be learned?
Well, I think the first lesson always is you never know when something good is going to happen. That is to say, you never know when a big opportunity or a big moment to take a big leap forward in expanding, what I would say, like the sphere of protection, whether you're working on worker justice issues or civil rights or anti-racism or protection of the natural world. We don't know what's going to happen, and always have your mind open to possibility. To us, truthfully, with the Ecuador, we even had conversations about, this could never happen within a national constitution at this point in the development of rights of nature laws. So maybe we shouldn't go to Ecuador. Ultimately, we said, no, we have to see what's possible. I think that's really important for any activist, whatever your cause is. But beyond that, I think we always have to kind of remember that it's really, really difficult to go first. Small communities in the United States actually went first. but Ecuador went first in the sense of a national constitution, a country doing this, and taking a huge leap forward. And it's really difficult to do that for any cause. And you have to understand that you have to kind of help create the conditions for that first leap forward to occur. And that first leap forward doesn't occur just once, which sounds strange, but it doesn't, because it happened at the local level in the United States, big leap forward, first community, and then other communities started to move in that path. Ecuador is just like the big leap forward for countries. And so we see other countries following in those footsteps. And it's kind of like you're not reinventing the wheel, but you're having the wheel created in new places. And I think that occurs within any level of activism. The first time a state recognized the right of women to vote, it has that first time, it's huge, but then it's hard, makes it easier for the next states, but it's still hard. And so we have to consider that as activists, that stuff moves slowly, it's difficult, and we do it because it's necessary. And we have to keep at it. It's time, it takes time. And I think within the natural environmental realm, this stuff is taking so much time, and we all feel tremendous urgency. Believe me, every day I feel it. But you have to just know that you're pushing forward, and you will see results, but you've got to keep at it, and that's hard to do. And I share, I share the concern, I share the frustration, of course, the urgency, but knowing that pushing forward, what other choice do we have, really?